develop with their collaboration an ADR mechanism for settling local sporting disputes that are cost-efficient, time-efficient, non-contentious, and also pre-approved by the governing association, so that it reflects what it is that they actually need. When I talk about local sports, I'm also including traditional Thai sports, of which there are 3 pictures here. There's a Chakra, I think on top, you can't see. Then there's a Muay Thai there in the middle. And then at the bottom, I think, is Garigalong, which is a type of a sword fight, very traditional in Thailand. So moving on to the midterm, we would need to inspire the next generation to be aware of using ADR to resolve sporting disputes as well. We already work with local universities, top universities like Chulalongkorn, Thammasat universities, other universities throughout Thailand to raise awareness of ADR in law faculties. Now, raising such awareness in sports faculties, of which there are several in Thai universities, would be a natural extension of that project. Currently, several universities offer undergraduate and graduate degrees in sports science and also sports management. And although law and ethics is a part of the elective curriculum of those degrees, ADR is not yet. So we hope to change that and bring ADR to the forefront for the next generation so they grow up to become fluent, as you can say, in ADR lingo and use ADR in their contracts and, that they either manage or develop with local sporting teams. Now, this is something that is an aspiration. It would involve several changes to the existing law to make this come to fruition, and that's why we put it in the mid to long-term range. We would, THAC hopes to see the protection of interim measures of arbitral sporting tribunals. I put a question mark there because this is something that is a little bit out of our control. The current law of Thailand, the Arbitration Act of W.S.W 2545, states that only the competent court would be able to impose provisional measures or an interim measure. So arbitral tribunals aren't allowed to do that yet. However, as you may know, that is actually a necessity to resolve certain types of disputes, definitely for doping matters where you would want the evidence to stay. You might need to order some type of injunction to prohibit certain actions from going forward. So that's why we've put that there as one of our hopes. To make this happen, we would need to work with sporting teams, sporting federations, sporting associations to generate awareness and make them see the need for this, and then we would need to work with public agencies to change the existing law to make this happen. Also, a long-term ambition of THAC is establishing ad hoc ADR mechanisms for national sporting events. Now, this is happening on a larger scale at CAS, which has an ad hoc division to administrate arbitration rules for large-scale sporting events like the Olympics. They've had that since 1996. CAS has also expanded this to include the Commonwealth Games and the Euro Football Championships. Now, if THAC is able to compile a core group of available experts, then we would hope to bring a similar mechanism to local sporting events, especially those that aren't familiar with ADR but have need for it. For example, nowadays the longtail boat national competition is a new type of sporting event, and something like that later on, if it grows to a larger scale, might need on-site arbitrators to resolve disputes immediately. So that would be something that we could work with them to develop if there is such a need. I'm just going to end my presentation with pictures of the THAC in Bangkok. As I mentioned, we opened in July of this year. So these are our facilities. Richard has been there already. It is in the heart of Bangkok, right in the Sukhumvit area, for those of you familiar with Bangkok. And these are pictures of our facilities. We have several types of rooms. We're on the 26th floor of Pirat Tower. which is also adjacent to the newest luxury shopping mall called M Quartier in downtown Bangkok. So video conferencing is there, and we have different types of conference rooms, different sizes. So this is the shopping mall to which we're adjacent to. So if you're ever in downtown Bangkok, come give us a visit. You know, if you're in a proceeding and you're bored, you can also go shopping downstairs, which is hopefully one of our draws. All right. Now I would like to thank all of you, Richard Wee. I'd like to thank KLRCA for having us here. Ending again with a picture of another female athlete. You know, this is where sports is heading, a female Muay Thai athlete. So thank you very much for your attention.
Thank you, Ms. Athita, for that very insightful presentation of the Thai Arbitration Center. Okay, our final speaker for the day, I believe, needs no introduction for those of us in the field of litigation in the Klang Valley. But I unfortunately have been informed this morning that our next speaker, Mr. Vinayak Pradhan, is currently suffering from a sore throat and will not be able to deliver the presentation which he intended to. However, so as not to disappoint his adoring audience this morning, Mr. Pradhan has agreed to say a few words for as long as his throat shall allow. But before we bring Mr. Pradhan onto the stage, maybe perhaps I could give a brief background of Mr. Pradhan's qualifications and experience. Mr. Pradhan is a chartered arbitrator and a consultant with the firm Skrine. He's also a member of the Permanent Court of Arbitration in The Hague, and of the Court of Arbitration for Sports, CAS, and was on the ICSID panels of conciliators and arbitrators. In his vast experience, Mr. Pradhan has presided in many arbitrations, both domestic and international, under the various rules of arbitration. Very vast experience, which includes ICC rules, SIAC rules, KLRCA rules, and the UNCITRAL rules. Having been described as one of the best arbitrators in Malaysia by Chambers Asia Pacific and Legal 500 Asia Pacific, Mr. Pradhan has also sat as an ad hoc judge over disputes which had arisen during the 17th Asian Games, held recently in Incheon under the CAS ad hoc rules issued by the International Council for Arbitration of Sports, or ICAS. Mr. Pradhan is also currently a commissioner with the Enforcement Agency Integrity Commission of Malaysia. Let's give a big hand to invite Mr. Pradhan onto the stage.
Well, first, thank you for those kind words. Lumpur, Tan Sri, Imran, ladies and gentlemen, I'm sure it is an occasion of joy for you when at an hour like this, which is advanced, and the doors for lunch are being opened, the speaker tells you, well, he can't say very much because he doesn't have the voice for it. Must have been a result of your heartfelt prayers. Now, much has been said, and we have had a comprehensive, excellent 3 presentations. So what I will do is perhaps restrict what I want to say to my experience first at the Asian Games in Incheon last year. The genesis of ICAS was mentioned earlier. It actually started during the time when Juan Antonio Samaranch was the president of the International Olympic Council. And it was at that time CAS was conceived to dispose of disputes arising during the Olympic Games. That was the principal function of CAS at that time. Because of a challenge to the Swiss court, not to the detailed extent we now have in Germany, when CAS is being dependent on the IOC, it was decided to separate CAS from the International Olympic Council, and hence ICAS was created, the International Council for Arbitration for Sport. And CAS became part of that organization, or they run it. So it became independent of the Olympic Council. Despite its origins were to deal with disputes during the Olympic Games, but things have changed so much that now the major work of CAS is in relation to football and doping disputes. In any case, it still has a role to play in the Olympics. In every Olympic competition, there are what are called ad hoc judges who are appointed to decide on disputes arising in relation to the Olympic Games. For the first time last year, CAS was asked to perform a similar function for the Asian Games, which were held in Incheon. But with the Asian Games in Incheon, the disputes had to relate to those arising during the period of the Games. So, for instance, qualification disputes, which might have arisen before the Games, were not within the jurisdiction of the ad hoc judges. There were 6 ad hoc judges who were appointed. There's one from the People's Republic of China, one from Papua New Guinea, the South Korean, the Vietnamese, an Australian, and one Malaysian. The disputes before the ad hoc panels are supposed to be decided within 24 hours of an application being made. And that 24-hour period includes the handing down of a written award, which, after being drafted by the 3 members who sit on each panel, have been sent to the president of the Asian Games CAS dispute board for his review and approval before it can be released to the parties. And all this has to take place in 24 hours. The president in this case was from Singapore. The form, so there's an application form which has to be filled. It's very simple. It's the name of the applicant, person representing the applicant if any, the name of the respondent, other affected parties, which could be other